Madam President, soon the Senate will take up the Foreign Intelligence Surveillance Act. It, of course, is known as FISA, and FISA may not be a household word to most Americans, but a properly written FISA reauthorization is exceptionally important to the well-being of our country, and it needs to meet a simple test. It must allow our country to fight terrorism ferociously and still protect our individual liberty. I do not know how many senators have traveled to the other end of Pennsylvania Avenue to personally read the legal opinions from the Department of Justice on the warrantless wiretapping program that is at the center of this debate. Someday, these opinions are going to become public. Someday, the American people will see how flimsy the legal reasoning is behind warrantless wiretapping. Someday, the American people will see the damage that is done to our nation when the executive branch tries to rewrite important national security law in secret. Madam President, the warrantless wiretapping program is not the first of this administration's counterterrorism programs that is built on legal quicksand. We have seen the coercive interrogation program, the detention program at Guantanamo. Again and again on these vital counterterrorism programs, the administration has overreached, it has fallen short, and then it has come to the United States Congress and asked that the Congress clean up these legal messes. I am especially troubled by the provisions in this reauthorization of the Foreign Intelligence Surveillance Act that grant blanket retroactive immunity to any telecommunications company that participated in the warrantless wiretapping program. I want to spend just a few minutes, Madam President, to unpack this issue and discuss why I think it is such a significant mistake to reauthorize the program in this fashion and to have what amounts to a blanket amnesty provision for those who may have been involved in illegal activity. Now, many have argued that the companies that were asked to participate in the warrantless wiretapping program should be treated leniently since they acted during a state of national panic and confusion. Now, Madam President, I've given this argument a lot of thought. And frankly, I think there's a valid rationale behind that thinking if you're talking about a short period of time. But that's not what's being discussed here. The warrantless wiretapping program didn't last for a few weeks or a few months as America worried about the prospect of another attack. It went on for nearly 6 years. At some point during that nearly 6-year period, any company participating in the program had an obligation to stop and to consider whether what they were doing was legal. Now, others have suggested that if you don't give amnesty to the companies now, it is going to be impossible to get cooperation from other companies in the future in the fight against terrorism. Madam President, I just don't buy that argument. Our country is full. It is full of patriotic citizens and businesses that are eager to do their part and to serve their nation. And I will say, I think it is insulting to suggest that American businessmen and women will be less patriotic if the Congress doesn't grant amnesty to the phone companies. The The people of this country love our nation, and I believe they step up. They come forward whenever they can. I hope, however, that they aren't going to say, well, okay, when the government breaks the law, we'll just automatically step forward in those instances. When American businesses are asked to participate in a program that looks like it could be illegal, we all say that's the time to hold on. I think it's important, particularly for our major businesses, to follow the law and not just the word of the president. I'm disappointed that this legislation includes this amnesty provision, and I hope, as colleagues continue to examine the bill, that they understand what is at issue. If the legislation passes, the Attorney General will be able to stop any of the lawsuits against the companies dead in their tracks. All the Attorney General will have to do is tell the judges considering these cases that any corporation that participated in the program was told by the government that what they were doing was legal. They won't have to actually prove it was legal. They won't have to provide any evidence. They won't have to cite any statutes. They won't have to make any legal arguments whatsoever. In my view, this amounts to self-certification. Self-certification runs counter to the whole idea of the Foreign Intelligence Surveillance Act in the first place. The Foreign Intelligence Surveillance Act is based on the notion that the way to keep classified intelligence activities from intruding on Americans' privacy is to make sure that there is a significant measure of independent judicial oversight. The judges in this situation would be allowed to examine as many documents as they like, but in this instance, they won't actually be allowed to exercise independent judgment at all. As long as they see a piece of paper, Madam President, a piece of paper that gets held up from a few years ago, a presidential permission slip, if you will, that claims the program is legal, they will be required to grant immunity to the phone companies. And even the distinguished leader in the House, the minority whip, has acknowledged, and I quote here, that this would be a mere formality. The concept of independent oversight that is so central to the Foreign Intelligence Surveillance Act and that has worked so well in practice simply, in my view, should not be transformed into an approach that effectively permits the administration to self-certify with respect to these particular cases. Madam President, I want to be clear that I cannot begin to divine how various matters in litigation will come out. In addition to the constitutional issues that are at stake, there are a number of contentious matters regarding standing, injury, a host of very difficult legal problems involved. I think that the judges in these cases will need to consider all of the issues if the cases go forward, and that is what makes the judicial process in the original statute so important. It's independent. They look at all of the factors that are relevant. But I will say that I don't think that I or the United States Congress should substitute its judgment for the judgment of the courts. And that is, in effect, what happens if the legislation goes forward as written and blanket immunity is granted to every company that participated in the program. Madam President, it saddens me to have to oppose the legislation as written, and I do so knowing that the bill contains a number of very important provisions and with respect to individual liberty and the rights of our people contains some significant steps forward. I'm especially grateful to Senators Rockefeller and Bond for working very closely with me to ensure that Americans who travel overseas don't lose their rights when they leave American shores. That is the status today, regrettably. And in this area, Senators Rockefeller and Bond and myself, Senator Whitehouse, Senator Feingold, a number of us who serve on the Senate Select Committee on Intelligence, worked in a very constructive way, in a good faith way, with the Bush administration. And now, in this legislation, we have put into law that in the digital age, your rights are going to travel with you. You don't lose your rights. Say if you're a serviceman from the state of Missouri or a business person from another part of the country, you wouldn't lose your rights when you leave American soil. That is as it should be. It is a significant expansion of the individual liberties of our citizens. They shouldn't give up their rights when they travel. They ought to have rights that do travel in a world with modern communications and modern transportation, and that provision is part of this reauthorization. But I will tell you, Madam President, I feel so strongly about the ill-advised nature of the provisions that provide for blanket amnesty that I must oppose this bill as written. I think when history looks back at what happened, the warrantless wiretapping program, they're going to say that this program, along with several other of the flawed counterterrorism programs that have come from this administration, was a mistake. We should not compound those mistakes by reauthorizing this legislation that contains a blanket grant of immunity at a time when I think Americans understand that it is possible to fight terrorism relentlessly, fight terrorism ferociously, without trashing our rights and our liberties simultaneously. We can do better. The Senate will have an opportunity to do better. A number of colleagues are going to be advocating proposals to strip the legislation of the amnesty provision. I hope those provisions will be successful. I would like to pass this bill when we have an opportunity to strike a better balance between fighting terrorism aggressively and protecting the liberties of our citizens. And with that, Madam President, I yield the floor.
Senator from Connecticut.
Before our colleague from Oregon yields, I just want to commend him for his statement. I had a chance to listen to part of it before coming to the floor of the United States Senate, and this is a long-held view of my colleague when it comes to civil liberties and the rule of law, and I commend him for remaining consistent in that insistence. And he's absolutely correct, I would say, Madam President, that this is not a choice between security or liberty. In fact, I argue, as he has, that when you begin to retreat on the rule of law, then you become less secure as a people. And we've learned that lesson painfully throughout history. This is a time for us to be vigilant, both in terms of our security, but vigilant and also when it comes to our rights. And this is an issue that ought not to divide people based on our determination